Good evening, students. We will going to start our next Law and Ethics paper 6. So with us, eminent faculty, sir, faculty, uh, Jatin Bansal, sir. Sir, you are in live? Please start,
Uh,
sir.
yeah, sure, sir. Good evening, sir, and good evening, students. Today we are going to start one very interesting law, that is Payment of Gratuity Act 1972. It is a labor law. So Payment of Gratuity Act 1972. So first of all, we need to understand what we mean by gratuity. What we mean by gratuity. So gratuity is simply thank you. Gratuity is thank you from the employer to the employee who has rendered a long meritorious service to the organization. See, you see now, if an employee is giving long service to an organization, long service, meritorious service to an organization, the organization is getting many sort of benefits. You guys are students of cost accounting course. You understand about the term labor turnover. Okay. As compared to other persons, you understand it better. That is labor turnover. In case, in case employees of an organizations are changing after say 6 months, after 1 year or 1.5 year, then what will happen? What will happen? Every time they need to recruit new person, they need to go for the screening process, they need to go for selection tests, and and what they are not only just incurring the expenses. Okay, so whenever they will getting the new employee, that employee will not be of much worth in the beginning. Say in the earlier 6 months, the person will be on training, the person will not be giving much to the organization. So if an employee is giving long service, is rendering long service to an organization, and that to unblemished service, यही नहीं ना सिर्फ की लॉन्ग सर्विस होनी चाहिए, it should be unblemished as well, like बेदाग, it is बेदाग. Okay, it is बेदाग service, unblemished meritorious service. So if a person is working in the organization and say doing fraud in the organization, and he's sticking to the organization for say 10 years, 20 years, then what is the fun of such person in the organization? So we need persons who have rendered long service, and that to unblemished, that is meritorious service. Organization need to say thank you to these employees in terms of cash, in terms of monetary payment. They need to say thank you. So it was held in the case of DCM versus workers. It is the this was held in the judge you can say Supreme Court judgment, that employees, workmen who have rendered long and unblemished service to their employee, to their organization, they have contributed, practically they have contributed a lot to the prosperity of the employers. So as they have contributed to the prosperity, excuse me, of the employers, it is the duty of the organization to give them something back. Okay, so this is gratuity. This is gratuity. So now, from the economic viewpoint, an employer is justified to pay gratuity because of the indirect benefits and costs saved by him over a period of time due to continuous service by the employee. If I told you, if a workman is providing continuous long service to the organization, organization may have saved a lot in terms of attrition cost, in terms of labor turnover cost. This act is applicable now to this act is applicable to whole of India, including this act is applicable to whole of India now, including the state of Jammu and Kashmir. It is applicable. All acts are practically now applicable on state of Jammu and Kashmir, like other India. So what is the app? This act is applicable from 16th September 1972. This act applies to whom? That we are going to cover here. This act applies to every factory. So meaning of factory we have studied in the Factories Act 1948 in 2 to 4 session. It applies to every mine, oil field, plantation, port, railway company. This act is applicable to every factory, mine, oil field, plantation, port, railway company. Okay. This act is applicable to every shop that comes under the Shop Act. Every shop or establishment that is covered under the Shop and Establishment Act of respective states. In India, if you want to open a shop practically or other office, you need to get registration with the Shop and Establishment Act. Basically, this thing is done by the Department of Industries, Department of Labor of the concerned state in every state. So every shop or establishment which is covered under the Shop and Establishment Act of the respective state, in which 10 or more persons are employed, 10 or more persons are employed on any day in the preceding 12 months. So this act is applicable on every factory, mine, oil field, plantation, port, railway company, on every shop establishment that is covered under the Shop and Establishment Act, in which 10 or more persons are employed on any day in the preceding 12 months. Beyond this, central government has got the power. This act has provided the power to central government. Central government may notify such institutions, such other establishment as may be notified by the central government, in which 10 or more persons are employed on any day in the preceding 12 months. Means if your establishment is not covered by A and B, okay, this is A, B. If your establishment is not covered due to A and B, but central government has the power in case your enterprise is employing 10 or more persons on any day in the preceding 12 months, central government by notification in the official gazette, they can do so. They can say that your institution will also be covered under Payment of Gratuity Act. By using this power, central government has made this act applicable to many motor transport undertakings. Like you see this Chandigarh transport undertaking, Delhi transport DTC, Delhi Transport Corporation DTC, then clubs, Chamber of Commerce like Federation of Indian Chamber of Commerce and Industry, SOCAM, then inland water transport establishment, local bodies, educational institution, societies, trust in which 10 or more persons are employed on any day in the preceding 12 months. So these institutions are covered by Act, like on every factory, mine, oil field, plantation, port, railway company, and every shop which is employing 10 or more persons on any day in the preceding 12 months. So these are covered by Act, and central government has got the power that central government by notification in the official gazette, they may specify some industries on which this act will be applicable. And central government has used this power. This is the power given to central government, and this is use of power by the central government. By using its power, central government has notified these industries on which this act will be applicable, provided they are employing they are employing 10 or more persons on any day in the preceding 12 months. Once this act becomes applicable to your establishment, once this act becomes applicable, and subsequent reduction in number of workers is not going to affect the applicability of the act. This means what? Say your enterprise was employing say 15 workers, and now this act is applicable. Now this act is applicable on you because you are employing 10 or more persons. Okay, so now this act is applicable on you. And in the next year, due to you are having lesser work in your organization or due to any reason, now there are just 9 workers working in your premises, working in your office, only in your shop, 9 workers are working. 6 have left or you have 6 have been retrenched, whatsoever the reason is. Now there are 9 workers only. Doesn't matter. Still the act will remain applicable because once made applicable, this act will continue even if subsequently the number of employees are reduced in the enterprise. Okay. So now I'm coming to the definition of enterprise, and now I'm coming to the definition of employee as given in this Payment of Gratuity Act 1972. What I mean by employee? Just a second. Employee means any person. Employee means any person other than apprentice. Other than apprentice. Apprentice means a person who has just come to gain knowledge. To gain knowledge, he is getting practically the training in our enterprise, and after the training, that person will leave us. It like CA apprentice, CMA apprentice. Okay, so employee means any person, it's a very important definition. Employee means any person other than apprentice nahi lena hai, that is employed on salary or wages, doesn't matter. If you have employed a person on salary, like that person is working in office doing some marketing job, etc., it doesn't matter, the act will be applicable. Or you have employed a person that is working in some factory, or the person is working in what, some oil field, doesn't matter, because that person is getting wages, doesn't matter, the person is getting salary or wages. In any industry, to do any skilled job, the person may be engaged to do any skilled job, doing any unskilled job, doing any manual job, maybe on any supervisory position, or maybe on any manual job, maybe doing managerial job, or maybe doing administrative job, technical job, clerical job for hire or reward, whether the terms of employment are expressed or implied. So what the law says, ki it applies to every employee, whether the person has been employed on wages or has been employed on salary. Maybe that person is doing skilled job, unskilled job, manual job, supervisory job, managerial job, administrative job, technical job, clerical job. Doesn't matter. Totally immaterial. Actually, uh, this was amended long back. You need not remember the year. Earlier, there were limit. Yeah, it is written. With the amendment in the Gratuity Act in 1994, the ceiling limit on wages have been removed, and every person shall be eligible for gratuity irrespective of his wage limit. Now this act is applicable on all. Like normally the what the act says, if you study the ESI Act, that will be giving you Employee State Insurance Act. That act will be giving you the limit. Bonus Act will be giving you the limit ki on up to, if an employee is earning wages, earning salary up to this, only then those act will provide him the benefit. Only then those act will provide him the benefit. But gratuities act is applicable on all. It doesn't matter. Salary limits, salary ceilings are immaterial now, and even it doesn't matter. If you see before the amendment, the provisions were like this: if a person is doing administrative job, okay, so gratuity was not paid, but this act says it in the payment of bonus act. But this act says what, a person may be doing any sort of job like skilled, unskilled, manual, supervisory, managerial, administrative, technical, clerical, doesn't matter. The person bus he should not be an apprentice. Other than apprentice, all are employees, whether employed on salary or employed on wages. Employee, um, excuse me. Employee does not include any person who hold the post under central or state government. Why is so? I'll tell you. Just a moment. Why is this so? Because this act was basically made for industrial labor. When this act was made in the year 1972, there was need. The private employer was basically not paying any gratuity or not saying thank you in terms of monetary payment to employees. So those employees were basically required to be protected. That's why under a welfare mechanism, this act came, and the purpose was a person who has rendered continuous service for a long period to an organization, they must get something in return, that is by way of thank you from the employer. So that's why this act was made. Okay. Central government employee or state government employees are already or they were getting gratuity even before this act came. So they need not any protection like this. They are already on better terms. Central or state government employees, they are already on better terms as compared to payment of gratuity act. So payment of gratuity act is basically for private sector, that private sector employers were not paying gratuity to their employees. So that's why this act came, that employer should pay gratuity to their workers. So what I mean by continuous service. So this is an important definition. You need to learn this section as well. But whenever I'll be explaining this term to you, it may not look very relevant to you right now. But after some time, you will say that this definition is very important. Okay, so please listen very carefully. Continuous service section 2A, we need to learn. An employee shall be said to be on continuous service for a period if he was in uninterrupted service during, including service which may be interrupted due to sickness, absence, leave absence without leave, layoff, strike, lockout, cessation of work, not due to fault of employee. Leave it for the time being. If an employee shall be said to be on continuous service for a period, कब माना जाएगा एक एम्प्लॉय कंटिन्यू सर्विस में रहा फॉर ए पीरियड? कब? Where an employee is not in a continuous service within the meaning of one, he shall be deemed to be in if you want gratuity, na, you should be on in continuous service for a period. This act basically says 5 years period. Continuous service. You should be in continuous service. If you have rendered continuous service of say 5 years, then you will be getting the gratuity. Okay. So what is how the gratuity, how continuous service is worked out, that we are studying. It says it says period of 1 year continuous service will be counted in this manner. I'm making a diagram, I'm making a chart for you here. Okay, not an issue. I'll explain it here only. Like for a period of 1 year, when 1 year continuous service is treated, there are different sort of establishments. Some works 6 days a week, some works less than 6 days a week. If your enterprise is like this, if your employer establishment is like this, that it works less than 6 days a week, it may be that it is working less than your employment, your establishment is like this, that it is less than, it is working less than, it is working less than 6 days a week. Okay, so it may be 5 days, 4 days, less than 6 days a week. Then, and your enterprise may be that is working 6 days or more in a week. 6 days or more. Okay, I'm presuming 6 days in a week. 6 days in a week. Okay. So that, then what is the meaning of 1 year? 1 year continuous service. Law says, in case of an establishment that is working less than 6 days a week, less than 6 days a week, if a person has worked for, if a person has attended office, actually work means not practically all working days, even Sundays will be considered that you have worked. Okay, if an employee has actually worked for not less than 190 days, minimum 190 days, you have got the wages for this period, you have basically actually worked for not less than 190 days, then law says it will be presumed that you are in continuous service for 1 year. And And what we mean by 6 months, what we mean by 6 months continuous service. I explained you that you will understand these terms after some time. Okay, after 5 minutes, you will be able to understand these terms. For the time being, you just need to understand what we mean by continuous service. In case of enterprises which works less than 6 days a week, less than 6 days a week, the rules are different. And in case of other enterprises, the rules are different. Okay. So in case of enterprises which are working less than 6 days a week, 1 year continuous service means 1 year continuous service means that the employee has got payment or employee has actually worked for 190 days, then 190 days, this means worker has continuously worked, he was on continuous service for that year. And in case of 6 months continuous service, they have simply halved it, that is 95 days. 95 days worked. If you have actually worked for 95 days, then for 6 months period, it will be presumed that you have worked, you were on continuous service. In case of enterprises which are working 6 days in a week, what for them? Law says, in your case, 1 year continuous service means if you have actually worked for 240 days minimum, and what 6 months continuous service in your case mean? This means half, that is 120 days service. Now, I'm telling you the meaning of this, importance of this. What is the importance? Under the Payment of Gratuity Act, normally, how much gratuity is paid to the worker? It simply says employer need to pay 15 days salary, 15 days salary for each completed year of service. You need to pay 15 days salary for each completed year of service, or or a part in excess of in excess of 6 months. This law says, normally what this act says, the employee will be getting gratuity payment at the rate of 15 days salary for each completed year of service, or a part in excess of 6 months. Say a person Virat has worked for 19 years and 8 months in a factory, in an establishment. Service is, what is the length of service? It is 19 years and 8 months. So now what? For 19 years, he will be getting the benefit 19 years into 15 days salary for each completed year service. Plus for these 8 months, this is a part in excess of 6 months. This is a part in excess of 6 months. For this too, you will be getting 15 days salary for this year too. So practically, this means you are getting the benefit of 20 years. Okay. You are getting the benefit of 20 years, 19 and 1. You are getting the benefit of 20 years due to this provision, that is 6 months continuous service. So the last part of your service may also be considered as completed year in case it exceeds 6 months. It exceeds 6 months. So now they need to ascertain whether you were on continuous service during that period or not. That's why they are telling you what we mean by 6 months, and what we mean by practically 1 year. So no, in normal enterprises, the rules are 1 year means 240 days service. 1 year means worker has worked for actually worked for 240 days, and 6 months means 120 days. And in enterprises which works less than 6 days a week, the rule is 190 days and 95 days. Now, These days, even if the worker has not worked, it will be presumed, it will be presumed that worker has practically worked for these days. Deemed to have worked, these are the days, these are deemed to have worked. Even if you have not worked, आपने काम नहीं भी किया ना इन दिनों में, लॉ मान के चलता है दैट यू हैव प्रैक्टिकली वर्कड फॉर दीज डेज, आपने काम किया है इन दिनों में. लाइक नंबर वन, ले ऑफ. Worker ke employer, sometime employer is not having work in his hand, he is not having the work. Then what you will do, what you will do in the factory when the employer is not having the work? So he lays off. During these days, it is not your fault na, it is not the fault of worker that he was laid off. So therefore if a worker has been laid off under the provisions of Industrial Dispute Act 1947, we will study it in the Industrial Dispute Act 1947, then law says even if you have not worked, even if you have not worked, it will be presumed that you have worked for these days. The period for which the employee was laid off by the employer under the Industrial Dispute Act, that period will be considered, that period will be included in his continuous service. Next is that period will be treated as if worker has actually worked, worker have actually worked, it will be presumed. Next, leave with full wages. I told you about earned leave in the Factories Act 1948. Earned leave is the concept under the, you can say it may be different from organization to organization, but under the Factories Act, the normal rule is what? If an adult worker, if an adult worker has worked for, if an adult worker has worked for 240 days, if sorry, if for every completed year, for every completed year, an adult worker will be provided, it was 20, for every 20 days you will be getting 1 day leave. Okay, so this was contained in the Indian Factories Act, the Factories Act 1948. So terms, so actually the rules for leave encashment, the rules for earned leave differ from enterprise to enterprise. Like for central government, in under the central government, what the rule is, we get around 15 days leave. We get 15 days leave, 15 days earned leave for every 6 months, and that too in advance. So these rules differ from enterprise to enterprise. So you need not learn these rules. I'm simply telling you, if an employee was on earned leave, okay, say in a month, the month is of say 30 days, 30 days. You have gone to office, you have actually gone to your office for 15 days, and for another 15 days you were on earned leave, you were on earned leave. Okay, so now for what period you will be getting the salary after, for this month? It was say month of November 2021, month was of 30 days. You have actually worked, gone to factory, you have actually gone to your place for 15 days, and for balance 15 days from 16th November, say 16th November to 30th November, you were on earned leave, you were on earned leave. For what period you are going to get the salary? Definitely you will be getting the salary for full month, you will be getting the salary for full month, because for first 15 days you have worked, for another 15 days you were on earned leave. Your earned leave account, your leave account will be debited for these 15 days, means your leave will be reduced and you will be getting the salary for the full month. You will be getting salary for full month. So what the law says, if a worker was on earned leave, then it will be presumed that the worker has actually worked in the factory. While in reality, you have not worked because you were on leave. But what the law will presume, that employee has actually, law will presume so, है ना, deeming provision. Law will deem so, law will presume so that you have worked, employee has actually worked in the factory. Third case is absence due to disablement caused by accident arising and in the course of employment. Say worker is working in a factory, okay? A worker is working in a factory or in some office, and suddenly one accident happens over there, okay? One accident happens over there, and due to that accident, he is disabled for some period, and he is disabled for some period, say for 3 months. Say for 3 months, the worker is not in a position, the for these 3 months, the worker, say for 3 months, the worker is not in a position to attend the office during these 3 months because he is disabled due to accident, and that accident had taken place in the course of employment. Then law says, as the worker was disabled and he was disabled, and that disablement was caused by accident, and that accident took place in the during the course of employment. So even during these 3 months, if he could not attend office, then it will be presumed that worker has actually worked in the office. He has actually worked in the office. In case of female employees, I told you under the Factories Act 1948, the female workers are eligible for maternity leave of 12 weeks. Maternity leave not exceeding 12 weeks. If a female worker was on maternity leave even during up to 12 weeks period, it will be presumed that she was on work, she has actually worked during this period. These are very important cases, because whenever you find a case study, you will be able to solve it only if you quote these things. Like there are four aspects. Number one aspect is what? Layoff. Number two aspect is what? Leave with full wages, that is earned leave. And third is absence due to disablement that has been caused by some accident. And number one, during the course of employment. And number four is what? That is female employees. If she was on maternity leave, not exceeding 12 weeks. Now, what about seasonal establishment? You guys are aware that in case of seasonal establishment, actually 240 days, how a person can work in 240 in an establishment, in a seasonal establishment for 240 days. If they are going to count it by this manner, then no person will be eligible for gratuity in seasonal establishments. So they have framed different rules for seasonal establishments. Like your company is doing, you are working in an ice factory, or you are doing work in any factory which is seasonal. Okay. So what the law says, if he is not in continuous service according to clause 1, chhod do, then he shall be deemed to be in continuous service if the employee has actually worked for not less than 75% of the number of days on which the establishment was in operation. If some establishment is in operation for say in total 100 days, okay, so out of those 100 days, if you have attended office, if an employee has actually worked for 75 days, then it will be presumed he was in continuous service during that period. There is no break in that. Okay, because a person may be on leave now, a person may be on leave without wages as well, but that doesn't mean break in service. That doesn't mean break in service. वो break in service थोड़ी हो गया. अब एक आदमी जो है वो छुट्टी लेता है बीच में, छुट्टी उसके पास अर्नड लीव पड़ी है तो आदमी अपनी छुट्टी कटवा देता है. लेकिन अगर उसके पास में अर्नड लीव अकाउंट में छुट्टी नहीं पड़ी हुई है, तो दैट पर्सन विल टेक द लीव विदाउट वेजेस. If that person is taking leave without wages, even then that person will not be treated as break in service. It will not be treated as break in service, provided the person has attended minimum number of days as is mentioned in 2A for that year, us year ke liye. Okay, so in case of seasonal establishment, if a person has actually worked for 75% of the number of days on which the establishment was open, was in operation, then it will be treated that you have worked for that season. Now I'm telling you one thing. In case of seasonal establishment, the gratuity rules are not like I told you 15 days salary for each completed year service. There the rules are 7 days service There the rules are gratuity payment will be 7 days service, 7 days salary for each completed year, for each season. 7 days salary for each completed, for each season. Then they will pay you gratuity at the rate of 7 days, 7 days salary for each season. Then rules are different in case of seasonal establishments. So now we will see the question. K is an employee of RST Limited, a software company which works 5 days in a week. So this thing is required to solve the question, that 5 days in a week wali enterprise hai. K was not in continuous service during the financial year 11-12. However, she worked only for 150 days because she was on maternity leave with full pay for 50 days. What they are saying? What they are saying, the enterprise is saying to Miss K, Miss, now she is a girl, na? So enterprise is saying to K that, ma'am, you have worked for 150 days only. As you have worked for 150 days only, actually worked. So you were not on continuous service. So this period will not be considered for your gratuity. They are saying this. While in reality, no doubt, this is they are uh, accepting that she has worked for 150 days. While in reality, she was on maternity leave for 50 days. Now, maternity leave for 50 days, it will also be presumed that she has actually worked during this period. So by this manner, she has practically worked in factory for 200 days. She has actually worked in establishment for 200 days. And now you know the rules as per 2A. As per 2A, continuous service, to consider for the purpose of continuous service, 1 year continuous service in case of establishment that works less than 6 days a week. In case of establishments that works less than 6 days a week, 1 year means 190 days. I told you this, na? In case of establishment that works less than, in case of establishment that works less than 6 days a week, 1 year means 190 days. 190 days the person has actually worked. So now you will say she has already worked. She has already worked 200 days in a year. So how the management can say that she will not be entitled to gratuity for this year? Okay. So referring to the provision of the Payment of Gratuity Act, decide whether Ms. K is entitled to gratuity, whether she is entitled to gratuity payable under the Act. So you will say yes. Would your answer remain the same in case RST Limited, the enterprise, works 6 days in a week? Then what will happen? Then you will say, sir, now she need to work for 240 days. Now she need to, as her enterprise is working 6 days in a week, as her enterprise is working 6 days in a week. So therefore, 1 year means 240 days service, sir, and she has actually worked for 200 days only. So she's not completing the requirement as contained in section 2A. So we can say she this period will not be considered. She will not be entitled to gratuity under the Act. Now she will not be entitled to gratuity for this thing. Okay. So this I have given full answer. So in this case, just see in the given case, K is an employee of company, a software company, which works 5 days in a week. K was not in continuous service during the financial year. However, she worked for 150 days because she was on maternity leave for 50 days. As per explanation given above, that is regarding these 4 points, that these period will be considered as if deemed to have been worked. So she has worked for 200 days and she will be deemed to be in continuous service. No, this is the answer to second question. If RST Limited works 6 days in a week, our answer will be changed. Now she has to work at least 240 days to become eligible for gratuity. So there is one more question. N is employed in ABC Company Limited, a seasonal establishment. The factory was in operation from 1st March to 30th June during the financial year 14-15. In total, the factory has worked for this much period. You know, in March, there are 31 days, and April, there are 30 days, May 31, and June 30. So in total, there were the establishment was open for 120 days. Okay, the establishment was in operation for 120 days. Although N was in continuous service during this period, he had worked for 95 days. They are telling you that the person has worked for 95 days only. So 95 days only. So now you see 122 days into 75% into 75%. So that will come around 90 91 days, 90 days. That will come around 90 days. And the Mr. N has practically worked for what? He has practically actually worked for 95 days. So now you will see that this season will be eligible since Mr. N has worked for 95 days, he is eligible for gratuity as exceeds the required 75% attendance. Okay, so it exceeds that. So in this manner, they may ask you the question and you can answer. So when is gratuity payable? When is gratuity payable? So I'm coming to that. Just a second. You guys, please tell me, are you able to see this hand notes? Are you guys able to see these hand notes? The payment of this act is called POGA. This act is called POGA. Payment of Gratuity Act 1972. The Payment of Gratuity Act 1972. So uh, this gratuity is also called, the gratuity is also called death cum retirement gratuity. People call it DCRG. People call it DCRG. Why they call it DCRG? It is death cum retirement gratuity. That is death cum retirement gratuity. It is normally this is paid on retirement, and on retirement this is paid to what? This is paid to employee on retirement, and it is paid on death as well. Say a person dies during service, then it is paid to his nominee or family member. Nominee or family member. So gratuity is paid in case an employee survives during service, then it is paid to employee. At retirement, it is paid to retired employee. And in case the employee dies, then it is paid to nominee. It is paid to nominee of the person or family. Okay. So in case the person has done nomination, then to nominee, or otherwise it is paid to family. Okay. So that's why it is called DCRG, death cum retirement gratuity. So what retirement means under this act? Retirement means termination of service. Service ki termination of an employee otherwise than on superannuation. So now you guys must be thinking of what we mean by superannuation. Superannuation means the maximum age that is prescribed under law, prescribed under the terms of service, that at which if a person reaches that age, then that person will be retired from service, even if that person is fit and fine. Doesn't matter. Like in government service, you find the age of 60 years, central government has retirement age of 60 years. If a person attains the age of 60 years, if a central government employee attains the age of 60 years, then that person will be retired, irrespective of the fact that that person is very fit and fine. It doesn't matter. The government will retire him. It is called, it is called retirement on superannuation. Retirement on superannuation. And simple retirement means what? Retirement other than retirement on superannuation. Retirement on superannuation means retirement on the age which has been prescribed, maximum age which has been prescribed under the terms of service, that at which if an employee reaches, if an employee attains that age, then that person will be retired, irrespective of the fact that whether the person is fit or fine, doesn't matter. And simple retirement means what? Retirement means termination of service, otherwise than on superannuation. So now I'm coming to definition of family, and why this definition of family is important, I'll tell you. Because if a person has a family, if an employee has a family, then this there is a you can say constraint or limitation that he can make the nomination only in favor of his family. Okay, he can make the nomination on any member in his family, but he can make the nomination um, on any member of his family only. Okay, so what we mean by family under the Payment of Gratuity Act? Family means spouse, first of all. Family means spouse. Then their children, matlab employee ke children, their children, married or unmarried, doesn't matter. We need to take simply children. We need to take children of employee. Doesn't matter whether those are married or unmarried, minor or major, doesn't matter. Dependent parents, parents will be taken if they are mainly, wholly and mainly dependent upon the employee, not otherwise. In-laws, again dependent in-laws, if the in-laws are dependent upon the person, only then they will be taken, not otherwise. Widow, widow and children of his predeceased son, say uh, 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 son of employee has died earlier, and he has left the widow, his widow, and you can say children, then those persons, those will be taken as part of family of the employee. Okay, so if I say by example, if we are talking about this person, then his spouse, if he's a male, his spouse, that is wife, their their children, that is beta, beti, son daughter. And if we take son and say son has son is predeceased, son has expired, then we need to take the widow, widow and son's son, that is grandson basically, or son's daughter, that is granddaughter. So we need to take any child, law or depend, or what about the parents? Parents parents will be taken, parents will be taken in case they are dependent, and in-laws will be taken in case, in-laws will be taken in case they are dependent upon the employee. So this is the meaning of family under the Payment of Gratuity Act 1972. Okay, any child lawfully adopted by him, any child lawfully adopted by the employee shall be deemed to be included in his family because the child has been lawfully adopted. And any such child which has been adopted by someone else, if he has given his child to someone else for adoption purposes, then such child shall be deemed to be excluded from the family of natural parents. Definitely, one, it will be included in one family. Na? The child will be included in one family. The family who have adopted, the family who have adopted, it will be treated as their family, and it will be excluded from the family of natural parents. Okay. When is gratuity payable? I told you, when is gratuity payable? Gratuity is payable if to an employee on termination of his employment. It may be due to superannuation. I told you, on attaining the maximum age that is required for superannuation. Even if an employee has resigned, even then he will be eligible for gratuity, retirement, or on his death or disablement due to accident or disease. Even then the gratuity is payable. Okay. And after one, when the gratuity will be payable to the person, I told you this act says that gratuity will be paid if the employee has rendered long and unblemished service. If the employee has rendered long and unblemished service. So what they practically mean by long service? Long service कि लंबी पारी खेलकर अगर रिटायर हुआ है बंदा, so उसको सलामी देनी चाहिए. Then we need to pay him gratuity. Then कितनी gratuity? Then what we mean by long service? Then law says continuous service of 5 years is required. But you please see, in case an employee has, there are some exception to 5 years continuous service rule. Okay, in routine, the rule is of 5 years continuous service. In routine, it is 5 years, 5 year continuous service rule. But this rule has certain exceptions. This rule has certain exceptions, and those exceptions are, say the employee has died, then what is his fault na? He has expired. Now employer need to pay gratuity to his family, even if the employee has not completed 5 years service. In case of death of employee, second thing is employee has become permanent incapacitated. Permanent incapacitated. The employee has become incapacitated, permanently incapacitated during the course of employment. Even now, the employee is not in a position to complete 5 years continuous service. In both these conditions, what the law says, employee is not at fault. So therefore, here his family and here the employee. In this case, family or nominee will get gratuity, and in case of permanent incapacity, the employee, because he is alive now, the employee will get the gratuity. He will get the gratuity even if they have not completed, employee has not completed 5 years continuous service. Okay, so now I'll see the doubts which you guys may have asked. Yes, I'm taking questions. Good evenings. Good evening. Ahira, sole proprietor does not come under this act. Any shop having more than 10 persons employed. No, sir. Even shop, a sole proprietor will come under this. It doesn't matter. They simply say any establishment in which any shop or establishment which is or in which 10 or more persons are working on any day. Okay. So even sole proprietor will come under this Payment of Gratuity Act. Any contractual employee is eligible for gratuity? Yes, sir. Yes, Mona Lisa. Even contractual employees are eligible for gratuity. Okay, very much entitled. Ahira, sir, maternity leave is mentioned as not exceeding 26 weeks in a study material. I'll check, beta, not an issue. Okay, if it is mentioned in your study material, then you need to go by that only. Okay. Ramam, in case of female employees, total period of maternity leave should not exceed 26 weeks. Okay. Whatsoever is written in study material, you need to follow that. You need to follow 26 weeks. Okay. You need to follow that. Sir, female employees 26 weeks. Ravi MJ. And then sir, Jammu and Kashmir में कौन सा act applicable होता है? सभी applicable होते हैं now after the abrogation of Article 370. Earlier, the situation was most of the acts, Indian acts were not applicable. Earlier, most of the Indian acts were not applicable in case of Jammu and Kashmir. But now all acts are practically applicable to the state of Jammu and Kashmir. Is there no chance of offline classes? I'm not aware. Institute will answer because I am far from home in Patna and just paying rent for room and mess. If there is no chance of, then I may move to home. Confirm, please. Sorry, brother, I'm not in a position to answer question like this. So, but I'll convey to the institute. So please confirm maternity 26 weeks, brother. If it is written in your module, you need to follow that. Okay, 26 weeks. For sugar industry, where crushing happens only for around 6 months in a year, is the payment there only for 7 days per season basis? Yes, sir. This rule will be applicable. What is earned leave? Earned leave means the period which you have earned. I'll give you a simple example. Okay, say your maid is working continuously, maid in your house is working continuously for say 20 days, 25 days without any leave. Then you see mama comes under tension. कि यार क्या हो गया इसको, 20 दिन हो गए हैं and she has not taken even a single leave. So she basically she has earned it, na? Your maid has earned it by continuous service. She has earned it. So that is called. That's why it is called earned leave. So earned leave rules differ from enterprise to enterprise. It differs from enterprise to enterprise. So if a person work for 10 years and exactly 6 months, should we consider as 11 years or 10 years? So in case of income tax, what we find, they always say we will pay 15 days salary. The employer will pay 15 days salary for every period, 15 days salary for each completed your service or a part in excess of 6 months. So in excess of 6 months का मतलब यही है, if you have worked 6 months 1 day, then it will be completed as treated as complete year, and 6 months will not be treated as complete years. ठीक है? So sometimes weekend also working, then about these days. We already treat those days as actually worked. Okay. We always treat, even if the weekends are not working, still we presume, we take that the employee has actually worked on those days. Yes, sir. Yes, sir. Yes, sir. Yes, sir. She can. Okay. 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 Visible, sir. Screen visible. Great. Yes, sir. Soga and Poga. Yes. SOGA is Sale of Goods Act and POGA is Payment of Gratuity Act. We have POBA as well. Okay, that is payment of we have POBA. That is, just a second. Let me write. That is payment of bonus act. Okay, that is payment of bonus act. We have TOPA as well. Okay, that is Transfer of Property Act, but that act is not in your syllabus. So law have some fancy names. So what if nominee also dies? I'll tell you, the person has not died now, the employee has not died. If nominee dies, then what's the problem? The person can always change his nominee. Okay. Visible, sir. Yes, sir. We can see the hand notes. Thank you. Okay. Then I'll write on the hand notes because that was the there I'll be getting a lot of space to write. Maji. Superannuation retirement are same, sir? No. Actually, superannuation is treated as it is a retirement. Superannuation is also retirement, but it is a retirement at which a person must retire. Say I am in central government service, if I attain the age of 60 years, even if I am fit and fine, then I need to retire from the job. This is called retirement on superannuation. And if I am not retiring due to superannuation, otherwise voluntarily I give some resignation or I take VRS from my organization, then I am retiring, but I'm not retiring on superannuation. Okay. How I recognize RSTs, enterprise or organized doesn't matter. It is applicable to anyone. Sir, is there any agreement the employee signed for 5 year service to get gratuity? Yes, he need to. In case the person has not rendered continuous 5 year service, the person will not be entitled to any gratuity under the Payment of Gratuity Act, except those two exceptions that I told you. Your explanation and notes are very nice. Thank you, sir. How much gratuity should pay to that employee in case of unsound and death? Sir, it will be worked as if the person has actually worked for 5 year service. Okay. So what is seasonal employment? Krishna Murthy ji, seasonal establishment means those enterprises which are not running throughout the year. They are running 6 months, 7 months, 4 months, 5 months in a year. Rasna, your explanation notes are very nice, sir. Thank you. Can you please explain superannuation? I have already done that. How much gratuity should pay after completion of 5 years? It will be 15 days salary. I told you, na sir. It is 15 days salary for each completed year service or a part in excess of 6 months salary. It will be worked out. It will be worked out on the basis of your salary. So if continue service for 5 years, 4 months, then how gratuity calculated? It will be calculated for 5 years only then. Then 4 months will be ignored. 4 months will be ignored. Okay. Because a period up to 6 months is ignored and a period in excess of 6 months is taken as one full year. What is meaning of layoff? We will study it in detail in Industrial Dispute Act 1947. Please explain exception to 5 year service once again, Lakshmi Priya. I told like if a person has died, if the employee has died, expired, then it is not his fault, na? Or he has become permanently incapacitated. then law will say that even if the person has not completed 5 years service, still that person will be eligible, or his family will be eligible for gratuity. In case seasonal establishment, gratuity pay is at the rate of 7 days wages for each season. Yes, sir. It is paid at the rate of 7 days for each completed season. I am appearing group one only. Can you provide me many method to get good marks? Okay, you need to study. Okay, this is the only principle that is applicable in case of professional exams. So what seasonal establishment? I told you, Krishnamurti ji, yes. Government employee gets gratuity. Yes, they very much get gratuity. Okay, so they have different rules. The CCS rules, Central Civil Services rules. Okay, they are governed by that, or and payment of gratuity act 1972 is not applicable on them. 15 days salary means gross salary. No, I'll tell you, they take basic salary plus dearness allowance. Dearness allowance, you guys understand, that is महंगाई bhatta. Dearness allowance, basic salary plus dearness allowance, and they take LDS, last drawn salary. I'll explain it later. Abhi aa raha hai. So what about gratuity for teachers? Yes. What components of salary be considered? Sir, I am telling it later. Then 4 years, 8 months will be considered for 5 years gratuity. Yes, it will be considered, Mona Lisa. You are right. So now I am coming to my part again. To whom gratuity is payable? I told you, normally the gratuity is paid to what? It is paid to employee. Definitely, we need to pay gratuity to employee. In case of death of an employee, it will be paid to his nominee. If no nomination has been made, it will be made to his legal heirs. Whatsoever his legal heirs are, it will be paid to them. Where such gratuity or nominee or legal heir is a minor, sometime the legal heir or the nominee is a minor, then this money is kept or invested. This money is kept invested in bank or financial institution for the benefit of such minor in the prescribed manner. Government will, appropriate governments will make the rules for that. They make the rules for that. You are not going to concern with that. Okay. So now I'm coming to amount of gratuity payable. How much gratuity should be paid? Okay. So employer shall pay gratuity to an employee at the rate of 15 days wages, 15 days wages based on the rate of, I told you what employer need to pay. He need to pay 15 days salary, 15 days salary or wages, doesn't matter. 15 days salary wages for each completed year of service. Each completed year of service or a part in excess of in excess of 6 months. This law says, okay, that is 15 days salary for each completed year of service or a part in excess of 6 months. This law says. So how this salary is worked out? They take LDS, they take last drawn salary. Now you guys may ask that why they take LDS, what is the benefit of taking this LDS, why they take LDS? Usually what you will find, if a person is joining a service, say a person is joining a service from here, okay, the person is joining a service, and what happens, his salary increases as he matures, his salary will also increase. And then on a day, the person will either retire or die. In case a person retires, then tell me when his salary will be the maximum. Now you guys need to tell me when a person usually gets maximum salary, when a person gets usually the maximum salary. Disablement is disablement. The person has got some injuries. Okay, the person is on the bed. The person is not in a position to move. Disablement, any sort of disablement. Major difference between superannuation and no, 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 no. There is no relation, sir. Lakshmi Priya, there is no relation between superannuation and annuity. Annuity is simply that employer or you can say the insurance company will pay monthly payment after retirement or after the fixed period. Okay, superannuation is It is related to, it is related to retirement. It is related to retirement. Okay. So giving both groups together is better or giving single group is better? Sir, it is always better to give both groups together. Uh, Actually, you guys don't understand Punjabi. If you understand Punjabi, I have one video on Josh Talks. Okay, you just simply search it by CA Jatin Bansal or on my Josh Talks. So I was a very क्या कहना चाहिए मुझे नालायक स्टूडेंट getting 8 or 16 in maths and English up to 5th standard. So how I pass my chartered accountancy exams, I have spoken on that. What technique I followed. I always say to students that they should always appear for both groups. It is always advised because you get the benefit of setting off. And even the big enterprises, the big companies, they always look for candidates who have passed both groups together. Okay. So there are, I'm not going to discuss much on that. Okay. So ceiling limit, how much? Sir, it is 20 lakh now. Now it is 20 lakh. 20 lakh is the ceiling. It has been recently increased. Earlier it was 10 lakh. Before that it was 3 lakh 50,000. So it was increased to 10 lakh. Now it is a 20 lakh. 20 lakh. What is the limit? 20 lakhs, sir. What are the difference between the regular employment, sir? I told you, Shweta Pandit. Would we have, I don't know. So at the time of retirement, yes, gratuity will be paid at the time of retirement or death. Sir, last drawn salary before death. Yes, yes, very good. So, sir, I have seen your Josh Talk videos. It's in Punjabi. You understand it? You understand it? Okay. Will you teach us ethics also, or are you only supposed to cover law? Sir, I'll be covering law ethics both, sir. Law ethics and governance. Okay, so both groups together is better or single? Sir, I told you it is always better. Okay, thank you. So now I am coming to fifth last drawn salary. Just only one student has answered that when an employee will get the maximum salary, that is LDS. Last drawn salary will always be maximum. Will always be maximum. So that's why it's a welfare act. Law wants to give you benefit for that. That's why they say last drawn salary, the last drawn salary of an employee will be divided by 26. Why 26? Payment of gratuity act treats that there are 26 working days in a month. They treat it. Actual working days may be more than actual working days may be lesser than that. Doesn't matter. Act has fixed formula that your last drawn salary will be divided by 26 and it will be multiplied by 15. Now practically this is 1 year benefit. Okay, this is 1 year benefit. Now we need to multiply it by the completed year of service. We need to multiply it by completed year of service, completed year of service, or a part in excess of 6 months. In excess of 6 months. Say we need to take some example. Say a person has worked for 11 years, 7 months. So now this 11 years, 7 months will be taken as what? It will be taken as factor will be taken as 12. 12 will be the factor. Say last drawn salary of an employee is 52,000. Okay. So now we need to divide it by 26 first of all, and we need to multiply it by 15. So each year, for each year, practically the employee will be getting 30,000 as gratuity, multiply by the year for which he has rendered service, that is 12. So the gratuity of the person will be 3,60,000. Okay, so this is manner by which gratuity is worked out. Okay, just a second. So now I'm coming in case of piece rated worker. You guys understand what we mean by piece rate worker? There are two types of methods to pay to the worker. One is time based and second is what? What is output base? Output base. Output base, that is piece rate basis. Output basis, piece rate, how output, what's result base, whatsoever you have given output, you will be getting on the basis of that. In case of piece rate worker, law says what? Average of 3 months wages immediately preceding the termination of the employment shall be considered as last drawn salary. Can anybody tell me why is this so? Why they have taken provision, made provision like this, that in case of piece rate worker, in case of piece rate workers, piece rate workers, why the law has not taken, why the law has not taken LDS? Why the law has not taken LDS? Why? Why the law has not taken LDS? Can anybody tell me the reason that why the law has not taken LDS? Yes, please. Sir, will you teach? Okay. So both group, ठीक है. Sir, what if we are doing BCom as well? It will be really hard to give both groups. Sir, everybody is doing BCom, sir. Everybody. Okay. You will not find even 1% student who are not doing BCom. So everybody who is doing CA, CS, CMA, they are doing BComs. Sir, it's simple Punjabi. Any North Indian can understand. Thank you, sir. So LDS means last drawn salary. Last drawn salary. So please tell me the limit of gratuity 20 lakhs. Yes, yes. There will be difference in payment. I forgot what about Yashoda you are asking. Company can fire employee under near to completion of five. They may. Okay. If you think your company can fire you, then ठीक है, they can do so. They can do so. They can always do so, but definitely if a person is a person would not like to you can say ki retrench a worker who has rendered 5 years service. 5 years service, you are an asset to the organization. They will not fire an employee. Sir, I actually enjoying your session. Thank you so much, Deepa. Because there is no salary, Chandan Singh, no, because they work for per week, no. Output fluctuates, so piece rate will be differ. Okay, very good, Mona Lisa. Piece rate is the base on how you output. Okay, that is okay. Piece rate salary will not be constant every month. Very good. At the time of retirement, sir, wage may not be constant, hence LDS is not taken. Okay, very good. Shravan Subramaniam ji. And due to low wages or capacity of person will be less. Due to low wages or capacity. ठीक है, okay. Good justifications. I'm telling you why, basically, why the LDS is not taken. If a person is on piece rate, na, what practically happens in the early phase of life, the person will not be much experience. And thereafter, the person, when once the person will get experience, he will be giving more output. He will be giving more output. Okay. Then a stage will come when he's of old age, or then what will happen practically once he leaves the job. So at that moment, his production would fall, his output would fall. So if the law pays on the basis of last drawn salary, then practically there it will be lesser gratuity. So it's a welfare act. It wants to give the benefit to the workers. So that's why it said that we will take average of these 3 months. We will take average of these 3 months. And once you will be taking the average, it will be greater as compared to the LDS. So to give benefit to the workers, what the law has decided that we will be paying in case of piece workers, average of last 3 months wages. Okay. In seasonal establishment, I already told you the employees who work throughout the year will be paid gratuity at the rate of 15 days wages जो थ्रू आउट द ईयर वर्क कर रहे हैं. However, employees working only during the season, if the employees are working, say an enterprise is working 3 seasons in a year, but enterprise is working for the full year. Enterprise is working, this is start of the year and this is end of the year. From here, this time to this time, for these 4 months, they are manufacturing product X. For these 4 months, they are manufacturing product Y. And for these 4 months, they are manufacturing product Z. So now whether the person will get 20 days, 21 days gratuity. No, no. Then the person will be getting what? Then the person will be getting 15 days gratuity for each year. This will be the rule. But in case some establishment is working like this, they say they have worked for 4 months only, 6 months only. Then what? Then law says कि employer need to pay gratuity. Employer need to pay gratuity, say for 7 days per season. Because the person is working in the seasonal establishment, then it will be 7 days per season. So now, what is the maximum limit of gratuity? Most of you were asking this question. Earlier, from 1997, from September 1997, this gratuity was 3 lakh. Maximum amount of gratuity limit was 3,50,000. With effect from 24th May, with effect from 24th May 2010, it was raised to 10 lakh. And now government has done what? With effect from 29th March 2018, now it is raised to 20 lakh. Now maximum amount of gratuity is what? 20 lakh. Actually, central government has raised the gratuity limit for central government and central government staff. So after that, the amendment was made in the Payment of Gratuity Act. It was brought by Payment of Gratuity Amendment Act 2018. And from 29th March 2018, it has been raised to 20 lakh. So now a question is how a gratuity should be paid to a worker which is disabled and has been re-employed, how the gratuity should be paid to that person. Now, oh, just a second, I'm doing it. No. हम्म, कैसे खुलता है? Yes. So how the gratuity should be paid to a person who is disabled, who is a disabled workman and has been rejoined at a lower post generally. Okay. So how the gratuity should be paid to the workers? Just a second. Is the slide, is the writing pad viewable? Is it viewable? Is it viewable? Please answer fast. Anyone? Is the slide viewable, beta? Is the PDF viewable? Nobody is answering.
Sir, it's visible, sir.
Okay. Okay, sir. Thank you, sir. Thank you so much.
Okay. Okay.
Yes. So how the gratuity is paid? Just a second. To a person who is disabled and has been re-employed by the employer. Okay. Who is disabled and has been re-employed by the employer. How it is paid? Dekho, you just see the case. In case a person was working in an establishment, he joined the service from here, and after say 20 years of service, that person has reached here. Now this is his LDS. This is his LDS. And due to any mishappening, now that person, an accident has taken place. Now person is not in a position to work on that job. Now, what the organization has done, the organization taking a compassionate ground, basically, what the organization has done, earlier he was working as some manager, marketing, or some other post, no, any post, you take it X post. He was on X post. Mr. Raju was on X post. He was on X post earlier. And now an accident has taken place. The person is not fit for this job now. Okay. So now they have posted him at a lower post. And now his salary is this lower post and he's ready to work at the lower post. Okay. So after say 10 years service, the person has got the retirement now. Once the person was 30, he joined the organization. He joined the organization once he was 30 years old. After 20 years of service, he was 50. He was 50. Then accident took place. And now the person has joined again at lower post. Raju has joined at lower post. After 10 years service, now he's 60 years of age. 60 years of age. So Now tell me, this is his LDS. How the gratuity will be paid to Raju? How the gratuity will be paid to Raju? Should it be this is now this is LDS? This is practically LDS. So should we pay it as per this LDS? If practically we pay him LDS as per this LDS, then his gratuity will be lesser. So considering this, what the act has done, they say this will be taken as his LDS1 and it will be taken as LDS2. So now what they are going to do, they will say LDS1 oblique 26 into 15 into 20 years of service. Okay, so this is the benefit for first service, and then for the service at the reduced rank, he will be getting gratuity, that is LDS2 oblique 26 into 15 into 10. So by that, the person will be getting total gratuity. This will be the total gratuity payable to Mr. Raju if this is the case. Okay. The gratuity if payable, gratuity payable is to a disabled workman that is re-employed by the employer. It will be computed in two parts. It will be computed in two parts. So now see this case. Mr. X was an employee of Green Sugars Limited. The whole of the undertaking of Green Sugar Limited was taken over by a new company named Modern Sugar Limited. Okay, some amalgamation or acquisition has taken place. Green Sugar Limited has been taken over by this Modern Sugar Limited. The services of all staff, the services of Mr. X remained continuous in the new company. Mr. X earlier who was working in Green, now he is working in Modern Sugar. After serving for 1 year, he has served for 1 year in the Modern Sugar. Mr. X met with an accident and became permanently disabled. Okay. So X applied to the new company for payment of gratuity, and the new company refused to pay the gratuity on the ground that Mr. X has actually served only for a year in the new company. The company is saying that you have worked for only 1 year only in the company, so you are not eligible for gratuity. So examine the validity of refusal of the company in the light of provision of the Payment of Gratuity Act. Okay, there is there actually this need to be answered in two manner. Okay, first thing is, if some enterprise has been reconstructed, like some merger, amalgamation, acquisition has taken place, then the service rendered by the employee in the old establishment will also be included for the new establishment. But in the current question, as it is not given for how much time Mr. X has worked in Green Sugar Limited, it is not given na. अदरवाइज जो पुरानी एंटरप्राइज में सर्विस करी है और जो नई एंटरप्राइज में सर्विस करी है, बोथ विल बी इंक्लूडेड. नंबर वन. नंबर टू, so Mr. X can further always say that as he has become permanently disabled, and in case of permanent disablement, 5 years continuous service requirement is not required. Okay, so 5 years continuous service requirement is not required. So you need to quote both the provisions and you need to answer accordingly. So new employer cannot escape from his liability for payment of gratuity in the present case. Now, explain the manner in which gratuity payable to employees in seasonal as well as other establishment is calculated. I have already covered that, section 4. And now, 4 feature of gratuity, very important provision, 4 feature of gratuity. Gratuity payments are very much protected by law, very much protected by law. Law simply says that gratuity of an employee whose service has been terminated for any act of willful omission, negligence, causing any damage, loss, destruction of property belonging to the employer, then gratuity can be forfeited to the extent of such damage or loss caused. Say, if an employee has caused willfully some losses, if an employee has caused willfully some losses due to the employer, due to his negligence, deliberate action, willful omission, then losses, employer is very much valid. Employer is very much valid if he forfeit the amount of gratuity payable to the employee uh, out of his out of his total amount of gratuity. If the employer makes some deductions for that, then this is valid. This is done. But for that, what is required? That employee, his services should have been terminated first. The employee has done such a misconduct that his services should be terminated. First of all, an employee, gratuity of an employee whose services have been terminated, due to what? For any willful omission, negligence, etc., that he has caused some loss to the property of the employer belonging to the employer, then gratuity can be forfeited up to the amount of damage or loss. Second thing, gratuity payable to an employee may be wholly or partially forfeited if the services of an employee have been terminated for his rowdious, for disorderly conduct or any other violence on his part. If an employee uh, he's doing rowdious, he has rowdious conduct, दंगे कर रहा है वो, कंपनी के अंदर आकर वो वायलेंट बिहेवियर रखता है ना, वो एक दो के ऊपर हाथ साफ कर रहा है, एक दो के चांटे लगा जाता है कंपनी के अंदर. If the employee has such behavior, then his gratuity can be forfeited. His gratuity can be forfeited. Or any other act, or any act on, on the part of employee which constitutes an offense involving moral turpitude. Moral turpitude होता है कि सभ्य समाज में असभ्य काम, है ना, uncivilized work in a civilized society. Then also during the course of employment, that during the course of employment, a male employee is doing what? He is teasing female employees or making unwanted remarks on them. So in that case, the services of an employee can be terminated, and gratuity and services, and you need not pay him any gratuity, because gratuity demands what? Gratuity demands good behavior, unblemished service. I told you unblemished service. Long beside longs, what is required? Unblemished service is also required. Na? Here the service is not unblemished, it is blemished. It is blemished service. So therefore, gratuity can be forfeited for that. So there is one case in Air India case, as well as in that you need to learn these cases. In Air India case, as well as in the Travancore Plywood Industries Limited case, courts have held that employers cannot withhold gratuity for non-vacation of staff quarters by the employees. Say you are working in an enterprise, you are working in a company, okay, any entity, and they have provided you residential accommodation. And now what has happened? You have retired, and after retirement you are not leaving government accommodation. Okay, बंदे की एम्प्लॉय की वाइफ कह रही है कि मेरी तो डोली यहाँ पे आई थी, अब मेरी अर्थी यहाँ से जाएगी, तो we will not move from here. So if this is the case, so employer cannot withhold gratuity, payment of gratuity to the worker for this task. There are two cases, Air India case and Travancore Plywood Industries Limited case. बहुत बार ये question repeat होते हैं, you need to say. So explain the provision for the payment of gratuity. For feature of gratuity, I have covered it, 4.6. You need to learn this section as well. This is a very important section, 4.6. You need to learn 4.6. Okay. And next is Mr. Y was working in ABC Limited for last 7 years as an accounts executive. He resigned from the services of the company on 30. He has rendered 7 years service. Okay. So he has retired from the services of the company on 30th April 2015. Achhi baat hai. His resignation was not accepted by the company. However, after serving the notice period, whatsoever was there, he stopped coming to the company. Now he is not attending the affairs of the company. After some time, he applied for his gratuity. The company refused on the ground that his resignation was not accepted. Company is quoting this reason: as your resignation has not been accepted, so we will not pay you gratuity. So discuss the legal position about this in the light of payment of gratuity act. So you can always write the provisions about 4.6. Okay, you can quote section 4.6 and quote its provision. Gratuity cannot be forfeited for this reason. Gratuity cannot be stopped, withheld for this reason. Okay. So the employee is you can say ki eligible for gratuity, and gratuity must be paid. National Steels Limited decided to forfeit the amount of gratuity of its employees A, B, C. National Steels Limited is an enterprise employer, is an employer, and these are three employees, that is A, B, and C. On account of disorderly conduct, their conduct is disorderly and other acts. What are their what acts they have committed? A refused to surrender the occupied land belonging to the company. I told you, if this is the case, practically this falls under you cannot withhold gratuity for this. B committed theft under law involving offense of moral turpitude. Here the gratuity can be forfeited and even it need not be paid. C, after superannuation, continue to occupy the quarter of the company for 6 months. Again, now the person will be eligible for gratuity. The person will be getting the gratuity. You can quote the case of Air India, or you can quote the case of Travancore Plywood Industries Limited case. Wajir Chand, this is also a practical case. Wajir Chand happens to be retired railway servant who occupies the government quarter and even after superannuation continue to occupy the government quarter. For such continuance, the government in accordance with the rules has charged penal rent from retired Wajir Chand. Okay, that is fine. And after adjusting the dues of the government, the balance amount of gratuity was offered to be paid. So whether the government can withhold this gratuity or not. So it cannot be done. The amount due towards rent can be recovered. This is a case, practical case. I told you Travancore case, Air India case. In these cases, it was held that gratuity cannot be, employee need to be paid gratuity. But what in Wajir Chand case, what was held? Gratuity need to be paid, but what the government can cover its dues from the employee. They can recover it. Now coming to almost last portion of the Gratuity Act, that is compulsory insurance, Section 4A. So you guys must be saying that, just a second. Oh, yes, it is visible now. Just a second. Yes. So you guys must be seeing that a person, if you are working in an enterprise, you must be seeing that if a person has completed 5 years of continuous service, now that person will start counting his gratuity every year after completion of every year service. He will say, now I have completed 5 years. So now practically I'll be getting at the time of retirement, at the time of resignation, I'll be getting 75 days salary. Okay. So after completion of 6 years, I'll be getting what? Now I am eligible for what? 90 days salary. He will learn the table of 15, है ना, proper. कि 75 days salary, 90 days salary, 105 days salary, 120 days salary. So in this manner. Practically, what will happen if a person has worked for say 30 years in a company? Okay, 30 years in a company. Now, the person will be thinking of that I'll be getting 450 days salary. Okay, 450 days salary. Now you can imagine the amount of gratuity that 450 days salary the person will be getting. But suddenly he came to know that employer has stopped business, employer has run into losses, he's under liquidation, and there are no assets left with him. So now how the employee will get the gratuity? This is a big problem. How the employee will get gratuity now? So to cover such cases, that these cases should not happen, Gratuity Act was amended in the year 1987. When the law came with the provision for compulsory insurance, that being an employer, it is your duty. It is duty of the employer to take compulsory insurance from LIC or any other private insurer. They need to take insurance that every year. Now what will happen? Every year the employer will pay the premium, the requisite premium to insurance company. Now, what will happen? Every year, the employer will pay the requisite insurance premium to insurance company. Now, gratuity will actually be paid by the insurance company. Employers simply need to pay insurance premium every year to the insurance company. And now it is the duty, it is the obligation of the insurance company to pay gratuity on retirement or on death. But this provision, this is one thing. Secondly, in case your enterprise is employing In case an enterprise is employing more than 500 or more than 500 employees, then they can go for what? They can go for establishing an approved gratuity fund. They can go for establishing an approved gratuity fund. It will work in the same manner. Na? Now every month employer will be paying money to this approved gratuity fund, to approved gratuity fund, and now the gratuity will be paid to the workers out of this approved gratuity fund. So if they want to do so, if an employee want, if employee and employer want to do so, if an enterprise is employing 500 or more than 500 employees, then they need to get it approved from the competent authority, from the controlling authority, that we want to establish an approved gratuity fund, a gratuity fund. Please approve that gratuity fund. Next is nomination. It is again, the section is important. Section 6. Actually, Gratuity Act has important sections. Section 6, nomination. Every employee who has completed 1 year of continuous service, law says, if you have completed 1 year of continuous service, you need to make a nomination. Nomination, that in the event of death of the employee, the money, the gratuity amount may be paid to the nominee. It may be paid to the nominee. In whose favor an employee can make the nomination. If an employee is married, then he need to make the nomination in favor of his family. Every person has nominee. If a person has a family, then he need to make a nomination in favor of his family. But if person is not having family, then he can make nomination in favor of anyone else. And a person can change his nomination a number of times. Okay, you can change your nomination. Nobody is going to stop you that how you are changing your nomination. If a person wants to change the nomination, he can change the nomination. Like someone asked the question, if nominee dies, then what happens? Not an issue. The employee will change his nomination. Next, protection of better terms of gratuity. This is again very important. Section 13. What it says. In case, देखो सरकार ने, government has provided this act, payment of gratuity act, as employers were not paying gratuity to their employees. So the government made the payment of gratuity act, the parliament made the payment of gratuity act 1972. Say your employer wants to or is paying or wants to pay you gratuity that is much more than this payment of gratuity act. Means your employer is giving you benefits of gratuity that are greater than, that are more than that provided under the payment of gratuity act, that are more than as provided in the payment of gratuity act. So law says you can choose, employees can choose for this benefits, other benefits, they need not be governed by payment of gratuity act. In case your employer, the right of the employee to receive better terms of gratuity, the right of an employee to receive better terms of gratuity under any award, under any agreement or any contract with the employer is protected. Okay, what the law has provided, this is bare minimum. This is bare minimum. If your employer is ready to pay or obliged to pay you more, then law has no objection to this. Okay, then law has no objection to this. But definitely say this is payment of gratuity act. Okay, and this is private. Your employer has designed this scheme. This is payment of gratuity act benefits, and this is your employer is providing you this gratuity benefit. Okay, say this gratuity benefit. An employee can't say in this manner that I would like to be governed by this provision of POGA and this provision of employer gratuity, this provision of employer gratuity and this provision of POGA. This is not allowed. You can't have benefits of both words. Na? दोनों आपको नहीं मिलेंगे ना. So you need to choose either you want to be governed by POGA or you want to be governed by employers on gratuity fund. Okay, so it is up to the employees what they choose. If the benefits under employer gratuity are greater than the POGA, then definitely they are providing better terms of gratuity, then employees can go for it. Okay, law has no objection. POGA law has no objection to this. The last term we are studying, it is employer's duty. The act has imposed duty on the employer to determine and pay gratuity. Gratuity shall be payable to the employee on the termination of his employment after he has rendered continuous service of 5 years. I told you, on superannuation or retirement or death. So on death, the gratuity is payable to the nominee, I told you, or legal here. And on retirement or superannuation, it is required to be paid to the workman, to the employee. A person who is eligible for payment of gratuity, whosoever it is eligible, like employee is eligible in case of retirement or superannuation, or the nominee or legal heirs are eligible for payment of gratuity in case of death. They need to send a written application to the employer, employee, or the nominee, as the case may be. They need to send a written application to the employer in the prescribed form within 30 days from the due date. That, sir, we are eligible for this payment of gratuity. Please pay us. As soon as the gratuity becomes payable, the employer shall, whether the application for gratuity has been received or not, it is the duty of the employer. He shall determine the amount of gratuity. He will calculate the amount of gratuity payable to the worker and give it notice in writing to the person. In case it is on retirement, then he will give notice to the employee. And in case the employee has expired, then he will give the notice to the nominee that so much amount of gratuity is payable to you, and you may collect this amount. The employer shall arrange to pay the amount of gratuity within 30 days from the date of its becoming due. It is duty of the employer that he will arrange the funds, he will pay the gratuity, and along with simple interest if it is not paid within this period. If the gratuity is not paid within 30 days, that employer will pay the interest as well for the delayed period. Okay. And after getting the approval from the compete controlling authority. So now see the question. Mr. X was an employee of Mutual Developers Limited. He retired from the company after completing 30 years of continuous service. He applied to the company for the payment of gratuity within the prescribed time. The company refused to pay the gratuity and contended that due to stringent financial condition of the company कि हमारी condition ठीक नहीं है, we are unable to pay you the gratuity. Is it a choice that employer will not pay gratuity? It's not a choice. Law says employer need to provide gratuity before. In case employer doesn't pay gratuity to the employee, it will be recovered as arrears of land revenue. It will be, gratuity is so much protected that it will be recovered as arrears bakaya. It will be recovered as arrears of land revenue. You guys understand? Land revenue, लगान, जैसे सरकार लगान रिकवर करने का राइट रखती है, बकाया कि अगर कोई आदमी लगान पे नहीं करता, in the same manner the gratuity which is not paid by the employer to the employee, it can be recovered from the employer. Okay. उसका मतलब ये होता है कि like first of all the appropriate authority, the controlling authority will give notice to the employer that you need to pay gratuity to the employee. In case that person still doesn't pay, then they will take over his enterprise. They will take over the assets of the enterprise. They will auction it. They will sell it. And after getting the proceed, they will pay it to the, they will pay DC होता है. It is basically deputy commissioner, duty of deputy commissioner, district collector. So district collector will do what? He will acquire the undertaking, he will auction the undertaking, he will get the proceed, and then he will pay to the employees their dues. And in case, even if the money is not sufficient, okay, even after selling the enterprise, if the money is not sufficient, occupier has asset, then private assets of occupier can also be auctioned for this. That's why it is treated as the most stringent way to recover the money. It is arrears of land revenue. Okay. So now law relating to recovery of gratuity, we have already covered. So what is the law? What is the law relating to recovery of the amount of gratuity under the Payment of Gratuity Act in case the said amount is not paid by the employer? I told you In case gratuity is not paid by the employer within the prescribed time, then employee can apply, entitled person can apply, they can apply to the controlling authority. Controlling authority shall issue a certificate for the amount to the district collector where the factory is established, where the enterprise is there, to recover the same along with the compound interest at such rate as may be prescribed by the central government from the date of expiry of the prescribed time as arrears of land revenue. They can recover it as arrears of land revenue. And again, the section is section important. It is an important section. I told you sections of payment of gratuity act are important. Okay, so before issuing the certificate for such recovery, the controlling authority shall give the employer definitely once any authority, any legal authority is taking any action, they need to provide an opportunity of being heard to the employer. That what is the reason why you have not paid to the employees their gratuity till date. So they may impose, I told you, they may impose interest as well for the late payment. Okay, so now I'm coming to your questions, and payment of gratuity act 1972 is done from my side. Okay, so now I'm coming to your questions. So would we have offline classes? Institute will answer this question. At the time of retirement or death, last drawn salary before death, before death. Yes, it will be taken. Last drawn salary will be taken before death. Sir, I have seen your Josh Talk video. Thank you. So would you teach us ethics also? Yes, yes. I have already covered this question. Huh? Yes. Sir, can fire? Okay, covered. Output fluctuates. ठीक है. अच्छा अच्छा. Okay. हम ऊपर आ गए. I'm taking it from the last one. So its written section 13 provides that no gratuity payable under this act shall be liable to attach in execution of any decree. Okay, very good, very good. I'm telling you this. What is this? This is an important provision. Okay, Ahira, I'm covering it. Like there is an employee, say name Rajan. Okay, there is an employee named Rajan. He's an employee. He's working in a factory. The name of the factory, he's working in a shop. Name of the establishment is what? It is XYZ Limited. He's working over there, employee. Rajan is an employee of XYZ Limited. So now what happens? Rajan has taken many loans, many loans. He has taken loans from banks, financial institutions, private money lenders. Okay, from every place he has taken loans. Okay, he has taken loans. So now this person is not having much assets. Much assets. This person is practically insolvent. Even to pay off these dues, to pay off these dues, and say this person has rendered 30 years service in XYZ Limited. Now the person has been declared insolvent. Now Rajan has been declared insolvent and he has rendered 30 years service and the job is still continuing. And he has LDS of his last drawn salary of 1 lakh rupee. So now you can calculate his amount of gratuity. It is this 26. Take it 1 lakh 4,000, 1 lakh 4,000. So 1 lakh 4,000 oblique 26,000, 26 into 15 into 30. So definitely it will be more than 20 lakh. So it will be restricted to what? 20 lakh. 20 lakh as gratuity. The person will be getting 20 lakh rupees as gratuity. You can increase it further, not an issue. In case if 1 lakh 4 is less than that, then increase the service to 40 years. Whatsoever. I'm simply saying you one thing that 20 lakh, the person is eligible for gratuity of 20 lakh. Now tell me whether the banks, financial institutions, can they go to his employer and say, as this person need to pay us our dues, so pay this 20 lakh to us. So law says this gratuity amount has got the protection under section 13 of Payment of Gratuity Act 1972. This money has got the protection. This money is for Rajan, or this money is for his family. In case Rajan dies, then this money is for his family and he has earned it. He has earned it. And this amount cannot be used in execution of any debt or etc. So इनको पे करने के लिए ये पैसा यूज नहीं हो सकता. This amount is to be used only for paying off to Rajan. Rajan को pay off करने के लिए ही this money can be used. Yes. Uh, is there a tax on gratuity? Yes, Akshar. Yes, it is there. It is there. Tax on gratuity. In case of central government or state government employees, definitely the provisions are like that, that whole amount of gratuity, whatsoever they get, they will be exempted. Okay. They will be exempted. It will be tax free. But otherwise, the provisions are there. You will study it in the direct taxes portion. You will study it in the direct taxes portion. Okay. So there are sections like this. There are sections like this. I'm telling you, we have section under section 1010. It is for it is, then we have 10 10A, and then we have 10 10 double A. These are sections of Income Tax Act. It is uh, उल्टा लिख लो तो आप ज्यादा बेटर वे में समझोगे. It is 1010. It is L, it is LPG. Okay, this is gratuity. This is gratuity, gratuity exemption, gratuity, and then this is pension exemption is under 1010A, and then we have leave encashment, leave salary, earned leave, that is exempted under 1010AA. So sections are like this. You will study it in direct tax portion, that how the salary will be exempted. Okay. So now I'm coming to more questions. Sir, who is more powerful, CA or CMA? Or sir, who is more competent? Brother, this question should not be asked any fast. This question should not be answered. Okay. All professionals are powerful and all professionals are at have their own place in society. Okay, so both are professional, CA and CMA, both are good. I'm a chartered accountant. I can't say CMAs are better. Okay, so you understand it better, or I can't say CAs are better. So person will get gratuity even in case of retrenchment. Yes, they get Ahira, they get retrenchment also. Sir, please give some tips regarding how to make self notes. Isha. Uh, uh, Beta, we have made notes for you. You just read them, learn them. Okay, law में ना मैं अक्सर कहता हूँ what is required. सिर्फ पढ़ना काफी नहीं होता. If you want to fetch good marks in law, then you need to understand that मैं बोलता हूँ law पढ़ना पड़ेगा, फिर समझना पड़ेगा, फिर रटना पड़ेगा, and फिर लिखना पड़ेगा. And in case you complete all the four, then nobody can fail you. Okay, nobody can fail you. पढ़ना, समझना, रटना, लिखना. But and रटना and लिखना is very, very, very important. Okay, in law. तो रटना पड़ेगा और definitely you need to make some self notes. So what we do, we are always trying to make the syllabus shorter for you guys. Okay, कि अभी आपने Factories Act morning में पढ़ा and now you have studied the Payment of Gratuity Act. If you study it, then it is for sure that you will be able to answer more than 95% of the questions in the exams. So can some company make an employment contract such that they may never have to pay gratuity? Uh, It's a welfare act. Gratuity Act is a welfare act. And definitely if some people make some contract that is to, I'll tell you an example. Okay, for this, just a second. Uh, you may have studied the concept of lifting of corporate wheel. Okay, there is one concept of lifting of corporate wheel. What we what we say, lifting of corporate wheel, that a company has a separate legal entity of its own and outsiders cannot sue. Outsiders cannot sue the members, outsiders cannot sue the directors, and a wheel is working in between. Okay, this is called the corporate, this is called the corporate wheel. This is called corporate wheel. And if outsiders want to sue the you can say members of the company, they can't sue. Okay, they can't sue. Why they can't sue? Because the corporate wheel is protecting them, so they can't sue them. If outsiders want to sue the company, they need to sue the company. You can sue the company, not an issue. You can sue. But if outsiders cannot sue the members. They cannot sue the directors. They cannot sue the directors. Okay. If they want to sue the directors of the company, they can't do so. Corporate will is going to protect them. Corporate will is going to protect them. So there are some cases where the persons, members or directors, they try to get undue benefit of this provision. Okay, the members, employees, management, they try to get undue benefit of this provision. They are doing something wrong. They are doing something wrong. Then law has the power. Law can lift this corporate veil. Okay, so there is one case on that, that is under statutory lifting. There are two types of lifting. One is called statutory lifting, and second is called judicial lifting. Okay, judicial lifting. So under judicial lifting, there is one case, that is Associated Rubber Industries Limited. Associated Rubber Industries Limited case. What happened in that case? Company was having, say, company was selling some products to people. They it was costing to them 10 rupee, and they were selling it to people for 50, and they were earning huge profits. And due to that, they need to pay huge bonus to the workers as well. They need to pay once your enterprise is earning good, you need to pay bonus accordingly to the your workers. So that was the case. Now, to avoid payment of bonus, what the occupier did, what he did. Associated Rubber Industries Limited created a fake company. They created a company, say ABC Limited. Now they started selling their product to this company for rupee 12, and this company was billing to the original consumers for rupee 50. So now this company has profit of 28, and this company has profit of rupee 2 only. But here there are no workers. There are no workers in this factory, no workers in factory. So by this, ABC Limited was earning profits, but it was not paying any bonus. Once you are not having any workers, then to whom you will pay bonus? So they were not paying any bonus. And in case of Associated Rubber Industries Limited, they were having profit of rupee 2. So they were not paying bonus to workers, or they were paying minimum bonus to the workers. And when the workers were demanding the bonus, they were saying, we are earning simply 2. This is our profit. If we are earning 2, what do you expect that we need to pay to you? क्या पे करेंगे हम आपको जब हम खुद ही 2 रुपए कमा रहे हैं? So this was the case. Then workers went to court, and what the court did, they lifted the corporate wheel. They lifted the corporate wheel to see actually who is this ABC. They found that the shareholders of Associated Rubber Industries Limited are practically the owners of Associated Rubber Industries Limited are practically the owner of what? ABC Limited. So practically the company was used to stop welfare legislation. The benefit that was envisaged under the welfare legislation, that has been stopped by making this company. So they lifted the corporate veil. So in this manner, if a person is making some provisions, that is to avoid welfare legislation, then other provision under various laws are there. How to remember section in law? Practice only, brother. Sir, they will consider LDS. Huh? Yes, yes, it is done, sir. Done. Okay, all doubts taken. So that's all from my side. Sir, do employee need to contribute for gratuity like EPF? Not exactly like that, but they need to pay if you have taken some plan from insurance company, from LIC, say. The LIC will tell you that this much you, on the basis of actuarial calculations, they will tell you that you need to pay so much to us for this year, and employer need to pay accordingly. Okay, so is if contractual employee for 1 year not mentioned about gratuity, then at the time of renewal contract, can employee claim for gratuity provision? Yes, he can. He can. Okay, sir, if a company senior management has done financial fraud, if they are in custody and hardworking employees who lost their job, Can they get gratuity and when? Definitely, you can get the gratuity from the employment establishment only. Okay, you are saying there is the senior management people, honor, I presume, they are in custody, and then what you can do if the company is there, it can be. I told you it can be recovered as arrears of land revenue from the company. Sir, gratuity is payable to an employee. What is the period of months? What is the period of months? It is payable within 30 days. Thank you, sir. Thank you. Can some company make an employment contract such that they may never have to? No, sir. No, sir. It is PF registry. No, sir. Okay. Thank you so much, guys. So I'll share the notes. Not an issue. Okay. Thank you so much. Thank you. Thank you, Sanjeev, sir. Thank you.
Thank you, sir. Shall you wrap up today's class?
Yes,
Hello,
sir.
sir. Shall you wrap up today's class, sir?
Yes, sir. Yes, sir. It's done.
Okay, sir. Okay. Thank you, sir. Thank you.
Thank you, sir.
Such a wonderful session, sir.
Thank
Good
you so
night, sir.
much. Good
Thank
night,
you,
sir.
sir.
Good night.
Thank you. Good night,
Thank you,
sir.
guys.
Thank you,
Thank you.
students, for participation. Thank you. Good night. Bye bye.
Bye bye, sir.
Thank you, sir. Bye bye, sir. Good night, sir. Thank you, sir. Good night, sir. Bye bye.